Thank you very much for the kind introduction, ladies and gentlemen. When talking about constitutionalism, I understand it as a socio-legal phenomenon which, in the spectrum, in the zoological garden of different models of ordering the life of a community, represents rather a species than a mere variety, which means that it covers a broad band of different approaches, all of which base the exercise of power on a constitutional framework as a source of legitimacy and on self-determination of the people. In this understanding, constitutionalism rests on the interplay of quite a number of legal, political, and social factors, and this makes it an ideal subject for socio-critical analysis. I will now present just a few salient features of constitutionalism: the direct application of constitutional norms, separation of powers, a more or less elaborate system of fundamental rights, a strong constitutional jurisdiction, an equally strong constitutional identity which reaches well beyond the naked text of the Constitution, which brings us back to this morning's topic: the underpinnings of the constitutional order, the effective dimension of a constitution. And then I would list the desire for stability, that is also a crucial topic which we discussed this morning, which the political powers do not satisfy, and finally the quest, the desire for a meta-democratic legitimacy. Now, constitutionalism, understood in these terms, has a number of more or less controversial implications. All of you know the suspicion of an anti-majoritarian bias. There you see the Daily Mail on the morning after the ruling of the Supreme Court, the British Supreme Court, on the Brexit, which held that Brexit must be based on an act of Parliament. Enemies of the people. Then we have constitutional amendments, which quite often are supported by a conjunctural majority which freezes specific political choices. And possibly most controversial of all of them, the possible preemption of political choices which might deprive the open debate of the necessary oxygen and might stifle democratic processes. Because there's nothing left to decide, because it's all in the Constitution. A related implication is the so-called micromanagement via constitutional principles, constitutional amendments as a common legislative tool, and finally the vision of constitution as a kind of mundane act. We know the idea, the medieval idea, many Asian cultures have this, religions, this vision that the construction plan of the world can be found in an act, the mundane act, das Weltenei, as Ernst Forsthoff termed it. It's everything is already there. We only have to discover it via constitutional implication. And I would like to present you 6 theses. First, constitutional is a legal as well as a socio-cultural phenomenon. Second, constitutionalism rests on an invasive constitutional regime which prevents political choices left to the legislature or other political bodies. It narrows the space for democratic processes far more than the traditional liberal constitutional doctrine would allow. Constitutionalism, and that's the third thesis, is often supported by the interplay between a rich constitutional texture on one hand and an underlying constitutional narrative which inspires a dynamic interpretation. Thesis number 4. Constitutionalism responds to certain weaknesses of the legislative and executive branches, of the administration of ordinary justice, or to what is widely considered a malfunction of the democratic process. Fifth, constitution reflects the desire of certain elites for stability and for non-political mechanisms to settle political issues. Final thesis, constitutionalism is essentially confined to fully pacified, saturated, risk-adverse, litigation-prone societies, as we might find them essentially in continental Europe, Western continental Europe, on one hand, and to fragmented societies which suffer from historic traumas or where national integration strongly depends on the constitutional order. And that's an expression of constitution which we would find essentially in a number of Latin American countries. From this perspective, the fully fledged constitution is confined to the old Europe and to Latin America. We could also discuss whether there is constitutionalism in the European Union. We have seen that the European Court of Justice operates as a constitutional court, and some facets, some implications can also be seen within the constitutional system of the European Union. Constitutionalism, as defined above as a specific socio-cultural phenomenon, is only emerging softly in the United States and in Commonwealth countries governed by the Anglo-American legal system. Still, although in these countries, constitutionalist moments may occasionally flare up. And one case is already the mentioned ruling of the British Supreme Court on Brexit, where it held in our constitutional system such a fundamental change of law as leaving the European Union would require an intervening act of Parliament. This is something that cannot only depend on an executive decision. The royal prerogative to withdraw from a treaty does not cover such a fundamental change of the British legal system. That's also a kind of constitutional moment, and you could term it an indication of emerging constitutionalism in the UK. Another case is a famous Irish case about European integration, where it was held by the Irish Supreme Court that certain steps toward European integration, from the Irish perspective, need a constitutional amendment based on a referendum. That was in 1987. I think it was the very first big case I was ever involved in. What are the legal factors which catalyze constitutionalism? First of all, it is the direct application of constitutional norms, which means the recognition of the Constitution's direct normative character, which also means that individuals may directly invoke constitutional norms, even if the legislative branch has not yet developed the provisions these individuals rely upon. And a salient example is the jurisprudence of the Constitutional Court of Columbia. The Constitutional Court of Columbia some years ago held that the provisions on non-discrimination imply a right of same-sex couples to marry, and it called upon Congress to legislate accordingly. When the Constitutional Court found that Congress had not lived up to this requirement, in light of the parliamentary abstention to implement the first ruling, the Constitutional Court held that henceforward all same-sex couples can register a marriage before any notary or any magistrate. Another pillar supporting constitutionalism is a strong constitutional jurisdiction coupled with judicial activism. And I'm well aware that the notion of activism is very controversial. It depends where you draw the median line. I just mean in terms of a value-free assessment, a certain amount of creativity, of going well beyond what the framers of the text would have possibly imagined. Examples for this strong constitutional jurisdiction coupled with judicial activism is Germany, in Latin America, Costa Rica, Colombia, Israel. I would be more reluctant to, it's a strong constitutional jurisdiction, but about activism I have my doubts. And we have the countermodel, the so-called submissive Constitutional Court. Here you see the Sala Constitucional, the constitutional chamber of the Venezuelan Constitutional Court, and in the midst you have President Maduro, and the court is grouping around the tribal chief, the president, the monarch, the dictator. In slightly different terms, possibly the Russian Constitutional Court might have certain submissive features, not quite as strong as the Venezuelan. Strong constitutional jurisdiction needs mechanisms to activate it. Open gates to constitutional jurisdiction, individual complaints for the protection of fundamental rights, so the mechanisms of amparo in Mexico, tutela in Colombia, public unconstitutional action in Costa Rica, applications by state organs of federated states, references by courts. And the outcome is that any German citizen can raise a constitutional complaint against Germany's participation in the European monetary policy. And we have quite a number of decisions. Or any parliamentary group can say, well, we challenge a rescue action of the armed forces in Libya because it wasn't backed by a resolution of parliament. That's the famous Nafura case. Which I won by a very narrow margin because the court held it was a case of urgency. We didn't need parliamentary approval. Or we have in Colombia public actions against acts of the legislative power where any citizen can challenge an act of Congress. We have also the mechanisms against private persons. They have a constitutional action against the publication of a book, for example. Or in Costa Rica, you have a public action against the government's verbal support of coalition in Iraq. That this is a violation of the constitutionally entrenched principle of Costa Rica's neutrality. The citizen just challenged this support of the then Costa Rican government in favor of the invasion forces of the coalition in Iraq. Then we have, as another catalyzing factor, the understanding of constitutional provisions as harboring values which must be defended, which must be implemented, which must be actively protected. Then we have the application of norms as a process of detection with creative elements. And most of you know the writings of Ronald Dworkin, who says the legal order is much more than just an accumulation of written principles and rules. There's a lot to be discovered. The application of the law is a process of detection. And then we have the balancing of principles and values, which bring forward new rules. And then we have what I call judicial activism, this creative approach, the Drittwirkung, the third-party effect of fundamental rights among individuals, and the development of other constitutional tenets. Then we have judicial rules where a decision drafts an entire legislative program, the famous decision of the German Constitutional Court, on the conditions, the parameters which must govern decriminalization of abortion. That the legislator may decriminalize abortion, but in the light of the human life, including of the embryo, the nascituras, as a value, the state has a constitutional obligation to protect this value. If it doesn't do so via criminal law, there must be a number of compensating legislative measures in order to protect the life of the embryo, both as an objective value as well as an individual fundamental right. Then we have, don't give you a translation, but just to see, it's like a notebook at school. The schoolmaster says, now you go home and that's your task which you take home. And in the same way, the Constitutional Court dictates a list of requirements to Parliament. It's very difficult to imagine that the Supreme Court of the United States, the French Conseil Constitutionnel, would ever think of doing. Then we have micromanagement by constitutional legislation. That many issues which from a traditional perspective are governed by ordinary legislation now are integrated and covered by constitutional amendments. And that, of course, indicates, as another feature of constitutional distrust of future majorities, the propensity to trigger cataracts of another set of constitutional amendments. The German Constitution, the basic law, dates from 49. Since we had 62 constitutional amendments. Colombia Constitution dates from 91. 42 constitutional amendments. The US Constitution dates from 1789, merely 27 amendments. In Latin America, we have now an interesting phenomenon in Colombia. We have the Acuerdo de la Paz, the Peace Accord of Havana, which is now largely integrated into the Constitution. It now forms part of what the French call le bloc de constitutionnalité. In Spanish, it's a bloque de constitucionalidad, the constitutional block. Nobody knows exactly how far this integration goes. But it's very clear that a large part of this voluminous piece of code now has acquired constitutional rank. Possibly the whole system of transitional justice as well. Then we have micromanagement, not just by legislation or constitutional amendments. We have micromanagement by judicial rulings. So cancellation of rent contracts become a constitutional issue in Germany. Quite a number of constitutional decisions. In Costa Rica, the Constitutional Chamber handed down a decision on an individual complaint against dust emissions from a public road. And the complainant stated, well, the dust from the road is soiling our laundry. And then the Constitutional Chamber ordered the state to tarmac the road within 18 months. A constitutional case. Or we have decisions in Colombia and other countries of Latin America on the access of patients to high-cost treatment. You have a patient suffering from AIDS. I don't get the necessary treatment. And then you get an order from the Constitutional Court acceding to this complaint. Now, this decision will not enlarge the public funds. And then the question arises, is this a facet of litigant Darwinism? Those who have the means and the stamina to go through the judicial system up to the Constitutional Court, they get the high-cost treatment, and the money is gone. And others won't get anything. Or is it, on the contrary, a necessary, an adequate response to administrative malfunction? Because what we have here is a malfunction of the public administration, which might legitimize this judicial micromanagement on the basis of the Constitution. Other factors are evolutive interpretation, which we may also find on international level, and then we have an interesting interplay between fundamental rights and human rights. We find this in the European context as well as in the American context, with the potential of certain counter-reactions. Now we have in Switzerland a pending referendum on the so-called self-determination initiative. Schweizer Recht statt fremder Rechter. That's something the Swiss people will vote upon next year. Now these were the legal factors catalyzing constitutionalism. I now turn to the political context and there possible the elements which I shall just maybe more controversially. I would submit that one element fostering, catalyzing fully fledged constitutionalism is a fractured political landscape, is a relatively weak parliament or a Congress without a marked ambition to assert authority in interpreting the Constitution. In other countries like the United States, there's an entirely different approach. The Constitution addresses Congress, and Congress is the first one to interpret the Constitution, at least in certain contexts. Which doesn't mean that Congress interpretation will always trump, but it means that the courts will take a more or less differential view towards this interpretation. There's no such ambition in the German Bundestag. Quite on the contrary, we have a parliament which is quite happy to sidestep certain constitutional issues, or an executive, and to leave them to the Constitutional Court. That would be the situation not only in Germany, it would be the situation clearly in Colombia, possibly in Italy. Well, in France we have an entirely different setup anyway. And the countermodel would be the United States, the United Kingdom, Switzerland, the mechanisms of referenda, which the French Constitution qualified as direct expression of the national sovereignty. Now, when you are confronting the direct expression of the national sovereignty, this will definitely have an impact on the degree of judicial control. Then we have an important role of the constitutional order for the maintenance of the state's legal and political integrity. It's not just the German concept of the Verfassungspatriotismus. We find it also in other legal cultures. In Colombia, we can say that the constitutional process since 91 is a kind of conflict management. In fact, the existing constitution of 91 was born out of the desire to solve an internal conflict and to integrate in extra-constitutional armed forces under the roof of the constitution. Now we have something similar with other guerrillas. The intent, the objective to integrate them on the basis of these peace accords in Havana, which not only have a humanitarian dimension, surrender of arms, transitional justice, but which also address participation in the political landscape, allocation of seats in both chambers of Congress. So it's the constitutional process response to the necessity of a conflict or post-conflict management. And then we have cases where it was the Constitutional Court that maintained the integrity of the constitutional order in light of attempts of the executive or other organs to overthrow the constitutional order in a coup d'etat. The probably most famous instance is a judgment of the Constitutional Court of Guatemala. In 93, the President Serrano intended a coup d'etat, declared the dissolution of Parliament, declared the dissolution of the Supreme Court. And just before declaring the dissolution of the Constitutional Court, the Constitutional Court intervened motu proprio. There was no constitutional action, without any application. Motu proprio, the Constitutional Court held that all these acts of the President purporting to dissolve the constitutional order were null and void. The Constitutional Court called upon the members of the government to ensure the publication of the judgment. That was crucial. And finally, it was the Minister of Defense and the Armed Forces that broadcasted the tenor of this decision. And this was the crucial factor stopping the coup d'etat by the President. And then there was a final order by the Constitutional Court where it said that all institutions of the state must and should continue with their constitutional function, and the Vice President should take over. So a very courageous decision taken without any application to maintain the constitutional order, and in my view a very noble example of constitutionalism in Latin America. The then President of the Constitutional Court a few days later asked me to submit an analysis of this judgment for publication. I did so, he thanked me, and a couple of days later he was gunned down in the streets of Guatemala. That's also part of the crude reality. where you have to fight for the integrity of the constitutional order. Then a final word on socio-cultural context. It's important to consider the socio-cultural reserves of interpretation. In our constitution, our legal system, we have a number of interpretational reserves. And many of them stem from the socio-cultural background, including experiences of dictatorship, of collective suffering. And in Germany, we have the constitutional protection of historic truths and the criminalization of Nazi propaganda as part of what I would call, as my interpretation, Germany's Staatsräson. The constitutional state of Germany defines itself through recognizing what happened during the Nazi times. And it's a very rare case, in fact it's the only case where we consider the protection of truth, of historic facts, as a constitutional value. In all other cases, you can go up and say, well, the earth is flat. Whatever you want, the sun is revolving around the earth. This doesn't disturb the constitutional order. Eve was created out of the ribs of Adam, and that's what I believe. Darwinism is wrong. You can say what you want. It doesn't affect any constitutional value. But in this specific case, as part of the constitutionally defined identity, not politically, constitutionally defined identity, the protection of historic truth has become a constitutional value. And that's why the Constitutional Court held that approval of the NS, or glorification, terror regime is an attack on the identity of the constituted community, and that glorification of the Nazi regime does not come within the scope of free speech. And that's a very striking example of recurring on socio-cultural reserves, or historic reserves of interpretation. Finally, we have certain developments where the concern that political choices might be all too rashly be determined materializes. And a very famous example is the case turning on in vitro fertilization, which is now allowed in many states, most European states, quite often with some additional legal requirements. And so in Costa Rica, the government issued a government decree, allowing in vitro fertilization for couples which found that this in vitro fertilization is the only means to found a family with children, because for biological, medical reasons they couldn't have children in a natural process. Then the Constitutional Court stepped in and said, no, in vitro fertilization is a violation of the fundamental right to life of the embryo, because in this process you create a number of so-called supernumerary embryos which are just disposed of. It's a very intriguing question whether these are persons, human beings, whether on the German constitution, whether they have a claim to human dignity, or whether only the embryo in the womb is bearer of human dignity. Anyway, the Constitutional Court, or the Constitutional Chamber of the Supreme Court of Costa Rica, held allowing in vitro fertilization violates the Constitution and violates also the American Convention of Human Rights as interpreted by the Supreme Court of Costa Rica. Then we have a complaint against this judgment, and the Inter-American Court of Human Rights finds that prohibition of in vitro fertilization, as pronounced by the Costa Rican court, violates the American Convention of Human Rights, the right to family life and other human rights. So in a way you have a clash between two different expressions of constitutionalism. The national constitutionalism, that's the Costa Rican court, and a kind of international constitutionalism. Yeah. The funny thing is, in this process, you never had a decision by Parliament. You have a government decree struck down by the Supreme Court saying it's already there in the Constitution. That's the mundane egg. We just have to open this Weltenei, and when we open it, we find, there's prohibition of in vitro fertilization. Huh? Because the creator of the mundane egg is gifted with a limitless foresight. He anticipated the issue, and now we just have to detect this constitutional rule. It's not spelled out. But if you look carefully enough, we find this prohibition. Then we have the Inter-American Court of Human Rights, which also uses the Convention on Human Rights as another kind of mundane act. That the solution is not spelled out. The Convention doesn't say anything about in vitro fertilization. Because at the time nobody knew about in vitro fertilization. But we find as an inherent ruling that the Convention gives the couples, the childless couple, a human right to the modern mechanisms of reproduction. So in the end, what is the conclusion? So if we have recourse to these mundane acts, these Welteneier, we end up with a complete dispensation from any democratic process. If the Costa Rican court is right, we need any democratic debate in Costa Rica. It's already there in the Constitution. If the Inter-American Court of Human Rights is correct, the result is similar. There's no need for any democratic debate. The solution is already written in the Convention. There's a right to it. So that would be my warning note. If we go too far in construing and developing and evolving the text, very often by having recourse to meta-juridical basis, conceptions of religious law, natural law, or liberal orders of well-being, then you cut out the space for a democratic process. My view is that neither the Constitution of Costa Rica nor the Inter-American Convention on Human Rights address the issue. That is, that there's a corridor for the political process, and that is a legitimate space for the democratic legislator, the Congress of Costa Rica, and an underlying democratic process. Concluding, I would just raise a question. Is constitutionalism, as I define it here, a Western concept? There may be other forms of constitutionalism. There may be so-called illiberal constitutionalism. Maybe Iranian lawyers, Miriam Nukla will present the topic tomorrow, might take the view of some rulers, yes, we also have a kind of constitutional, possibly, but it's not the kind of constitution as I define it here. So my question is constitution with the characteristics I tried to present to you, is it a Western concept? Or is it, in worse, an exclusively Western concept? My good friend Thomas Frank, 20 years ago, raised a similar question in a very famous article. Is freedom a Western value? And he came to the conclusion it's not a Western value. We must give other societies just time. Societies in Africa, in the Middle East, in other parts of Asia, South America, give them time. It also has taken us centuries to develop our concept, constitutional concept of freedom. In any case, the impact of social and cultural context indicates potential for change. That would also be the thesis of Fareed Zakaria in his famous book, The Future of Freedom. That if you want constitutional order, constitutionalism, rule of law, good governance, you must establish the meta-juridical basis for this, economic basis, social basis. And then you can have a reasonable expectation that this plant will grow. Then we have the constitutional basis of national identity in post-colonial Latin America. But you could say, well, Latin America, in a way, is part of the Western legal culture. We have other examples which document the dependence of a constitutional order and constitutionalism on external factors. The extraordinarily swift demise of the Weimar Constitutional Order in 1993. And on the other side, more positively, the rather swift transition to constitutionalism in post-communist Eastern Europe. All this ratifies the importance of joining the normative and the social cultural basis of constitutionalism. And this corroborates, in my view, that the analysis of law as culture is crucial for understanding the underpinnings of constitutionalism and all its different expressions. Thank you very much indeed.